on the record in 2024 TR 617, State of Kansas versus Abel Estrada. Paul E. Dean for the state, and Mr. Estrada appearing in person and pro se. The defendant was found guilty February 14th, 2025, ordered to pay scheduled fine in 108 within 15 days. And what have you done about that, sir?
I submitted the notice to appeal.
Okay. And have you done anything to perfect that appeal with the Kansas Court of Appeals?
I'm waiting. I literally just spoke to the court record, and they send it in, and the next thing is we're just waiting for the plea.
All right. First of all, I'm not making if Mr. McClendon has not withdrawn, I'm having him do so now, because we do not, to my knowledge, pay for appeals of illegal tags. You'll need to be responsible for that yourself. And it's not enough just to file the notice that you intend to do it. You need to actually do it. So are you going to be representing yourself or hiring an attorney on that, Mr. Estrada?
I would like to get an attorney.
Well, you're going to have to hire one, because throughout the trial, you kept insisting that you, if I'm remembering correctly, you didn't want an attorney. Isn't this one where I made Mr. McClendon stay on as kind of a backup counsel?
That's correct, Your Honor. He was essentially became standby counsel, and the court granted Mr. Estrada basically special consideration on this matter, as this is not even an offense that's eligible for court appointment, as it does not carry a sentence that exceeds 6 months.
Oh, yeah, yeah.
And I thought the court, maybe I was going to double check the journal entry. I was thinking Mr. McClendon, maybe even on the last journal entry, had been allowed to withdraw, but there was delay in me giving the paper, those journal entries to the county attorney's office, because I had a few to complete after that day. So they had not all been emailed in. So I think they might still be in the process of being e-filed, because then the following week, as I recall correct, I didn't travel to Greenwood County because of all the snow.
Okay.
I did my meeting with the commission via Zoom. So, but today the court's ordering that Mr. McClendon is withdrawn. Mr.
Yes,
Abel
because
directed to, or advised he should perfect his appeal.
And I'm going to set his pay or appear over 30 days to see if, and remember, you were to pay a $15 or $158 cash bond. Did you do that when you filed your notice of appeal?
I'm sorry. Can you repeat that again?
I had ordered that if you appealed, you had to pay a $158 cash bond. Did you pay that appeal bond?
No, I didn't, but I was trying to get a waiver.
Yeah, he's definitely going to need a waiver. Think about it. If he's forced to post an appeal bond just to guarantee the state gets their money when his appeal inevitably fails, how on earth is he supposed to fund more fake license plates? I mean, come on. This is exactly why reality doesn't care about confidence or theatrics. You can play the system all you want, but the system always collects its due.
Well, I haven't seen anything about a waiver. Mr. Dean, have you seen anything about a waiver on his appeal bond?
No.
Well, I would deny any appeal bond. Mr. Abel, the facts in this case were very straightforward. You'd made up or bought a made up alleged tag that wasn't even close to being a legal tag. We spent a lot of money trying it, and I say a lot of money because I made the defense attorney stand by, even though you didn't want an attorney. Now you say you want an attorney to appeal it. Well, I'm sure not going to appoint one to appeal it. And if you cannot even afford your $158 appeal bond, I'm wondering how you're going to afford your attorney if you can even find one to take this kind of case on appeal. I would venture to suspect that it's never been done before, but if you think you can get it done, you're welcome to. But I am proceeding that until that appeal is perfected, you still owe $158 fines and costs, and you need that to pay that appeal bond. So I'm going to review this in 30 days, and you better have it all figured out, or you better have it all paid.
I actually started the process, and I send the appeal notice, and I actually send I requested what's it called? The report. No, the journal entry from Mr. Dean office, but I haven't got it because the journal entry reflects $50, but I never got it. I never seen the charges or the journal entry. I'm trying to get all the information in.
That's all great, Mr. Estrada. The journal entry is being filed. Your Honor, I don't know that at least the state's not particularly interested in his steps to appeal. That's for him to figure out on his own. I do have one item to correct on the record, Your Honor. I think probably it's proper to note that Mr. Estrada was wanting counsel. However, both court-appointed counsels, Mr. Paul and Mr. McClendon, both believe that Mr. Estrada was also wanting them to violate their oath as an attorney and make arguments
that is incorrect.
Don't interrupt, please.
And make arguments in violation of both the U.S. and Kansas Constitution was the specific statement both attorneys made to this court.
Yes. So,
that was all. I just wanted to correct it because he was asking for an attorney, even though, quite honestly, the case doesn't qualify for court appointment.
Oh, thank you for correcting the record.
The court still did grant him that an attorney, but the attorney's basically. Mr. McClendon became standby because he believed that the arguments were not supported and were in violation of his oath.
Oh yeah, that's right. Two separate attorneys independently said they couldn't represent Mr. Estrada. Why? Because doing so would force them to pursue a legal strategy they both believe would violate their sworn oath to uphold the Constitution. And honestly, this is one of those classic courtroom moments. You walk in, look around at a room full of lawyers and judges, and all you see are people completely out of their depth. Except, in this case, the real problem isn't them. It might just be you, Mr. Estrada, who's constitutionally incompetent enough to think this nonsense could actually work.
And it looks like from my docket notes, he was just ordered to pay 108 court costs. It says scheduled fine, but isn't this a misdemeanor?
I just asked for the basic fine. What I refer to as basic fine. It's not really a scheduled fine, but it was $50 because he did actually have it. He just refused to
put on his car.
Display it.
That's right. He refused to put it on his car. Put on that cardboard.
Despite all the rigmaroles, I treated it just as any other case.
Okay. All right, Mr. Estrada, we're going to make you come back for another pay or appear in 30 days. Missy, when is that?
March 28th at 11 o'clock.
All right, March 28th, 11 o'clock. We're going to review this and see if you paid your case and moved on, or if you're going to keep fighting it and you understand. Never mind. All right, but I understand, Mr. Estrada. What is it you're appealing? The fine and court costs, or are you appealing the verdict?
I'm appealing the verdict.
Okay. And you want to maintain your argument that cardboard tag was legal. The tag that you made was legal.
Yes.
Okay, all right. I just wanted to make sure I knew what we were doing here. All right, I'll see you back here March 28th at 11 unless you paid your $158 balance. Thank you, sir.
Yeah, I just wanted to know, where do I get the report, the journal entry from Mr. Dean?
It'll be with the court. Look at the court.
The clerk of the district court is the keeper of journal entries.
You mean the court record?
The court records are all through the clerk of the district court.
Okay, thank you.
They're the public record holder. Yes, sir. And that's about all I can advise you. I'm not going to help you practice.
All right, here's where we're at. He's got 30 days to either pay the fine, post the appeal bond, or show up in court and convince a judge why he shouldn't go to jail. And that brings us to our next hearing, because this one's special. Enter Judge Ricky, a no-nonsense, zero-tolerance kind of judge who shuts down a sovereign citizen before they even get a chance to start. No theatrics, no back and forth, just straight up authority doing its job, and it's absolutely satisfying to watch.
Jesse Travis McLaughlin.
Yeah.
It's the state of Kansas versus Jesse Travis McLaughlin. It's case number 2024 CR 397. Mr. McLaughlin appears from a Hutchinson Correctional Facility Zoom location. Brett Sweeney appears for the state of Kansas. Mr. McLaughlin, I have before me a charge of battery against a law enforcement officer, a level 5 person felony. Since a felony is involved, you will not be asked to plead at this time. Rather, a preliminary hearing scheduling will be made before your assigned judge, which is the Honorable Jan Satterfield. Judge Satterfield's next docket for that purpose would be April 7, 2025, 2:30 p.m. You must fully participate by Zoom in Judge Satterfield's docket at that time, April 7, 2:30 p.m. I trust, Mr. McLaughlin, that you, being in prison, don't have the financial resources to hire your own lawyer.
That's all right. I can represent myself.
Okay, well, you can take that request up with Judge Satterfield. At this point,
Every
in
man
the
must
abundance
speak
of
for
caution,
himself, Your
I will
Honor.
appoint a lawyer, and then you can, before Judge Satterfield, properly conduct a proceeding if you really do want to
Point
represent.
of order. What gives you jurisdiction to appoint a lawyer over me?
I have statutory authority to do so.
Since you asked, here's the reality. KSR2 2453 literally states that it is the court's duty to inform you of your right to legal counsel. Not only that, but the court is required to assign an attorney from the panel of Indigenous Defense Services if you don't have one. In other words, this isn't optional, it's baked into the system. You can't just opt out and pretend it doesn't exist. The law has your back whether you like it or not. See.
So, Mr.
So
Kaufman,
what
I'm
gives
going to
you
appoint a lawyer at this
what
point.
gives you jurisdiction over me? You must establish jurisprudence as a point of order.
I'm not going to play your sovereign citizen gibberish game.
I'm not a sovereign citizen, sir. I'm
All
not a
right.
sovereign citizen.
You sound like one.
Well, I'm not.
All right. I assure you I have jurisdiction. So we've got a court date set before Judge Satterfield. I'm going to appoint James Watts at this point to represent Mr. McLaughlin, noting he's made a request to represent himself. Again, that's to be a matter taken up fully before the assigned judge, Satterfield, at the hearing date on April 7 at 2:30 or some later time. And the court will set a $5,000 cash or professional surety bond, though obviously it's not going to affect his current incarcerated status. All right, bond set, attorney appointed, court date established on Judge Satterfield's calendar. Anything else we need to address at this time, Mr. Sweeney?
No, Your Honor.
Mr. McLaughlin? Apparently not.
Yeah, you need to address the point of order. As a
I've
first
addressed
point
all of
order
the
in
points
court
of order that I'm
first
inclined
thing
to address
you must
today.
do is establish
Mr.
your
McLaughlin.
jurisdiction.
The McLaughlin matter is currently in recess, and we'll move on to another matter on the docket.
I object to moving on in any manner.
Objection noted and overruled, Mr. McLaughlin. All right, let's move
Request a
on.
copy
Okay,
of-
then.
I
Thank
request
you
a
to
copy
the
of the
Hutchinson
minutes,
Correctional Facility.
transcripts, these proceedings.
We can go ahead and take him off the meeting at this time.
Alright, we're officially done with single cell cerebellums in Kansas. Now it's time to take a field trip over to Michigan, where the sovereign Neanderthals are roaming the streets, armed with fake legal theories and zero common sense. Trust me, things are about to get just as chaotic, if not more, and you won't want to blink.
And who is the individual? And sir, what is your name at the jail?
I'm Roman Cavill. I mean, I can place my status on the record if you like.
Yeah, hold on one sec. Yeah, I'll get to you 1 second. I need to look over some things. Are you
Yes.
representing yourself?
No, sir, I'm not representing myself. I'm presenting
Okay.
myself.
Okay. I mean, do you have is a court appointed attorney going to be speaking with you, or are you going to have a retained attorney?
No, sir.
Okay, calling case Tom King 25 William Boy 00474 in the matter of Roman Curtis Campbell. Mr. Campbell, would you please state your name for the record?
Yeah, I like to state
Just tell
my
me your
name.
name. Yeah, go ahead. Yeah, all I have to do is say it.
I'm Roman Curtis Campbell, a natural person in full life.
Okay, let me ask you this question, Mr. Campbell. Let's try not to talk together. I mean, I'm going to allow you plenty of time to talk because I have to. But are you representing yourself here today? You don't need an attorney, or you want an attorney?
No, sir, I'm not representing myself. I'm presenting myself. I don't need
Okay.
another man to present.
Are you presenting yourself? So you don't want an attorney, you're presenting yourself here today. Is that correct?
Yes, sir.
Okay. All right. Thank you, sir, for that.
You're welcome.
You're charged with domestic violence, as I've indicated. MCL 750.81, it carries a maximum penalty of 93 days in jail, possible fines of $500 and/or both, not including any court costs. I am going to enter a plea on your behalf of not guilty on this offense. You will be given an additional, and you're also charged with refusal for collecting fingerprints and data, which the court is ordering that you do that. As I've indicated, I'm entering a plea of not guilty on your behalf for this matter. I'll indicate that you're self-representing at this time as well. I do have some other conditions for you before I set bond. You're not to have any direct or indirect contact with Marissa, Maurissa Smith. You're not to return to the premises known as Celeste Road.
That's my home.
I'm gonna keep going, and then I'm gonna take all your questions at the end. So, no problem. It's not. Just hold on to that question. That's all. You're gonna have plenty of time to talk at the end. So, do not return to the premises known as Road, West Bloomfield. You will not assault, beat, verbally harass, intimidate, or threaten any potential witnesses. Person may appear for all court proceedings. Do not leave the state of Michigan without permission of the court, and immediately notify the court in writing of any change of address or phone number. You need to provide the court with a valid address within 24 hours of your release. Do not leave the state of Michigan without permission of the court. You will not possess any firearms or other dangerous weapons. You shall refrain from using alcohol, any form of THC, illegal drugs, or using any medication. You must contact pretrial services within 24 hours of your release. That's at the 48th District Court in Bloomfield Hills. Pick up no new criminal offenses. And I understand you're self-representing yourself here today. The court will set a bond in the amount of $1,500 cash surety, no 10%. Sir, do you understand your bond, what I read off to you, your bond conditions?
Yeah, I understand all of that, but all of that.
Okay, now I'm gonna take your questions right now. Thank you very much. So what questions do you have for the court?
Can I place my status on the record, sir?
Absolutely, sir.
Okay, I'm Roman Curtis Campbell. I'm a natural person in full life, in propria persona, sui juris serheritis. My nationality and citizenship being Moorish American national, unconditional heir, apparent vessel for the Moroccan Empire.
Well, if you're really the heir apparent vessel to the Kingdom of Morocco, someone should probably call the Moroccan king and let him know that one of his princes is back in jail again. And just to put things in perspective, check this out. I'm standing here at the Moroccan castle in central Portugal. That's right. I've literally visited more authentic Moroccan heritage sites than almost every one of these so-called heirs who parade around claiming the throne. So moving forward, you shall refer to me as
I come at Northwestern Mexico, at North America, North Gate, Turtle Island. I come under protection, by way of Treaty of Peace and Friendship, 1836, between the United States Service Corporation and the Moroccan Empire. I also would like everybody else that's involved with this matter to place their status on the record, and so that it can be noted. And also, I'm not representing myself. I'm presenting myself. Not only that, I'm not standing a surety to Roman Curtis Kemp Hill in all capital letters, ins legis, corporate entity. So that be noted for the record, please, sir. I also reside in domicile at. That's my address. That's my home. The defendant, witness, or whoever that is, Marissa, she doesn't live there, and so that's where I was kidnapped from. That's my home, sir.
Okay, and I will allow you to go back there one time and one time only with a police escort to obtain some minor personal property. That's with a police escort only. Otherwise, you cannot go back to that location.
I'm going to pause right here to make a quick point. Normally, when the victim doesn't live at the location where the assault occurred, but the defendant does, the court doesn't typically bar the defendant from returning. Simple, right? But this guy decided to decline a lawyer and represent himself. And what did he do? He went ahead and mixed a heaping pile of sovereign citizen nonsense right next to the actual relevant facts. And the judge either didn't hear it or didn't care. This is exactly what happens when you choose to represent yourself. Chaos, confusion, and the front row seat to your own train wreck.
You have another court date coming up. Your next court date is going to be your pretrial date. That date will be provided to you prior to you bonding out. If not, you're going to have to contact the 48th District Court in Bloomfield Hills. Other than that, best of luck to you, sir. Officer, we're all set here. Thank you very much for your time.
If I could, Your Honor, we would like the refusal of the booking process, that he not be released until that is completed.
Absolutely, he must submit, as it relates to the booking, he must submit to the booking processing in this information, including fingerprints, which is the biometric data. He must provide that information prior to release as well. You're all set, officer. Thank you.
So I'd like one more thing, sir. I'd like to invoke my treaty right to consular jurisdiction. I've been asking someone to be that's competent in the notification and access manual, and I haven't been given that right. My rights have been violated as far as all of that's concerned, also. So
okay, make sure you mention that to the judge when you see the judge. So thank you very much, sir, for that. And officer, we're all set.
Thank you, Your Honor.
Okay, must submit the biometric fingerprint data prior to release.
Alright, that's definitely someone we'll be seeing again soon. But for now, let's move on to our final hearing. Because if you thought things were wild so far, trust me, the finale is about to take it up a whole new level.
Motion? What do you have to add to it?
I'm wondering if you got those check stubs that I've entered in.
I didn't get any check stubs.
So
oh yeah. Wait a minute, I did get some check stubs. Yes, you were the one that did have them. Yeah, I had a question on those because you got 2 support notices on each stub. So do you have more than one case?
Yes, sir.
Okay, how many children do you have?
2.
Okay, this one and another one?
Yep.
Okay, because I was trying to figure out, I have a feeling that what's happening is they are maxed out on how much they can take out of your checks. The reason that you keep getting hauled in is because you're not paying the full amount of child support.
But at the time that they was taking the money out of my checks, they issued the warrant.
Right. If you owe $100 and they only collect $70, you're gaining $30 a month in arrears. And once the arrears hit a month, well, that's why I was asking, because the amount of child support that is are these weekly checks or monthly?
Weekly, sir.
Okay.
It's 440. It was receiving that, and at the time.
And how much did they say that you owe?
Just now, recently.
Yeah.
They said I was in arrears just 5,000.
Okay. Yeah, because I have a feeling that's what's happening. Now you have the right to have this child support reviewed at this point in time. It's been 3 years since the last order, so it can be reviewed for you. But
my whole thing is, I I wasn't paying because last year, April,
Mhm.
they got a $5,000 check on my behalf
From whom?
from an employer, from a settlement, which was from an employer.
Okay, and they confiscated all 5,000.
Yep, it was.
Okay, and that should have gone against any arrears. Now their next question would be, are you sure they got it?
Child support?
No, the $5,000 check.
Child support got that $5,000 check.
Are you sure they got it?
Yes, I'm sure they got it.
Because what I would do if I were you is ask for an accounting of the case to make sure they got it. An accounting will give you a computer readout of every month that you owe and every payment that's been made, and they do it in writing. So if you write them and ask for an accounting of your child support, because some of this stuff will not be in the court file. The court file is a public file, so the court does not know how much your arrearage is unless they apply for a show cause. Okay.
And I haven't been paying recently because I was under the impression that the obligation is $445 a month.
Well, it looks like how have you not been are you not employed anymore?
I'm at work right now.
Okay, well, it's because the employer automatically takes it out.
Right. I just started this job, and
okay, then you have to notify the front of the court what job you changed to, so that they can apply it to the appropriate. Because they issue an automatic income withholding order. Again, that does not go in the court file because it contains some very specific information about you, and you don't want that public information.
This is what I'm trying to say to you, sir.
Hmm?
They received $5,000 last.
And I told you what to do to deal with that.
April.
Yeah.
I was under the impression cover the rest of the year. I did not know that they.
No, they don't cover anything forward. They only cover things currently owed.
Right. Okay.
They can't hold money forward. If they have an overpayment within 48 hours, they will send you back a check for the overpayment.
Okay. Well, they still was in breach of contract.
No, they weren't. Child support isn't a contract. It's a statutory obligation. Sure, you may have signed papers in the past acknowledging your responsibilities, but that wasn't creating a private agreement. That was you formally recognizing a legally mandated duty as a father. It's not something the state can breach or opt out of, because this isn't about negotiation or consent. This is the law doing its job, whether you like it or not.
There is no contract. This is the law. That's not a contract.
Is this Zoom just about child support?
Yeah. Sorry, Ms. Cry. That's what his motion's about.
And
so,
why did I have to join? I'm thinking this for
well,
because
you have a motion?
Yes, I do.
I have a motion for child support and an amended motion for child support. Those are the only motions before the court.
My motion wasn't about child support.
What was your motion about?
It was basically just for me trying to get his rights and stuff revoked. I did all this stuff.
We don't revoke rights in a parent in a family law case.
You should have been getting some paper. I did all this stuff.
Well, that motion would be automatically denied because we do not revoke parental rights in a family law case. That has to be done in a neglect case.
In a what case?
An abuse neglect case.
So why did they have me filling out the papers?
I have no idea. I don't know what papers you filled out. I don't have them. Okay. So I'm sorry. I didn't know you had a motion. But I was going to ask for your input before we finish this. I'm just trying to deal with his issues on child support.
Okay.
He seems to be under a misapprehension that this is a contractual relationship, and it's not. It's a statutory relationship.
Okay.
The front of the court is following their statutory authority to collect child support on behalf of the child. So that's what's necessary, and they will automatically follow their rules and the statutes in doing so. The court tells them when or if child support should be reviewed. And again, I've informed you, sir, Mr. Miller, you have the right to ask for a child support review if that's what you're asking for. But yeah, if you're not paying support, they're going to be hauling you in to explain why you're not paying.
Well, I also was sick.
Okay, that's fine too. But again, you're going to have to explain why the payments weren't being made and why you owe.
Payments wasn't being made because I was
You're under a misapprehension, not an understanding. So That one I can tell you you're wrong on. So the best you can do is ask for an accounting to make sure that all money is accounted for and all payments are accounted for. Now, do you want this sent to the front of the court for a child support review?
I want this case closed and dismissed.
It's not going to be closed and it's not going to be dismissed.
So even though they were receiving the full monthly obligations, it's okay for them to.
If you owe, they're going to haul you in to find out why you're not paying the amount.
And we wasn't receiving I wasn't receiving no full amount.
Well, ma'am, part of this, you're not going to receive the full amount. You're on state aid. The reason that this case was brought, it was brought by the state of Michigan because of your state aid. When you're on state aid, the state mandates the child support be paid in accordance with the law, and then they confiscate portions of that child support to reimburse the state for what they're paying on behalf of the child.
Is this Admiralty Maritime Court law?
No, it's not Admiralty Maritime Court law. This is the state of Michigan. We are not in the middle of an ocean.
Because the flag in the back got a gold fringe on it.
Yeah, don't even do that bull. That's a bunch of bull.
You have
it is a United States. I don't know what you're receiving, ma'am. But this case was brought by the prosecutor's office on behalf of DHHS because of state aid involvement.
Oh. I don't receive anything. I haven't since
okay, well then once you stop that, then you should be receiving the full amount, but the state will confiscate part of anything that's still owed to them from any child support collected. Right now I'm not sure how much the arrearage is. Obviously there is an arrearage. So no, the UCC, the Uniform Commercial Code, does not apply to this court, sir. This is a family law court.
That you don't have on the gown either, so you're not.
You're right. That's because I'm an appointed judicial official, not an elected judicial official. So yes, I have a full authority. I am sworn in. I am an attorney prior to being this in my judicial capacity. So yeah, I have full authority, and the authority is given to me by statute as well. So I follow the statutes, the laws that I have to follow.
So this statutes and codes. It's not actually law.
It's not code. It's law. It's statutes. It's the laws of the state of Michigan.
Statutes and codes.
Statutes, no codes. The Uniform Commercial Code does not apply to this court.
Ouch.
All right. Do you want the child support review or not, sir?
I do want the child support review.
Okay. In that case, I will send this for a child support review. Ms. Cry, any questions, ma'am?
Nope.
All righty. I will look at your motion when I do receive it, ma'am. I don't know when it's scheduled for, but it was not scheduled for this morning. Okay.
Oh, that's what I thought this was for.
Okay. Yeah. No problem. This was for his motion.
Uh-oh.
All right. Have a good morning to both of you. I'll send this to the front of the court for child support review. Have your most recent current pay stub available. Both of you.
I'm under the impression that there's a warrant.
You do have a warrant.
I didn't notice a warrant, but that wouldn't come up on this file for this motion. That would be a separate issue. You might want to call the warrant department if you believe there's a warrant, because you can deal with that.
Okay? I wasn't properly served on.
Again, the court has no paperwork concerning any of your warrant. I don't have her paperwork for her motion. I can't advise on things that I don't have before me because I need to look at them before I find out if they're properly served or not. Call the warrant office and find out what's going on if you believe there's a warrant. This is the first I've heard of it.
This is the motion for support.
This is the motion for support, and that's why I'm sending it to the front of the court for child support review.
And this all is under the same thing. Why they issued the warrant? Supposedly.
No, that's separate issues. This is ongoing support. Your warrant is about back support, if there is one. Okay. Yep. Two separate departments. All righty. Good luck. Have a good morning. Take care, everybody. Motion's granted for support. Review.
All right. That wraps up the hearing, but not quite the video. The judge had a little extra wisdom to drop, and honestly, I love it. Admiralty court style, shutting down nonsense left and right. It's so satisfying to finally see judges push back on the chaos that is the sovereign citizen movement. If you enjoyed watching this train wreck get handled, smash that like button. If not, well, hit dislike, but don't leave without dropping a comment below. And make sure to subscribe with notifications on, because you won't want to miss any of the chaos, the breakdowns, and the courtroom fireworks I'm bringing next.